Here.
All right, because I want to save that song for another day, Dan.
Okay.
All right.
All right. So, Lisa, I've made you co-host, so you should be able to mute and unmute yourself. Uh,
Excellent, thank you.
yep. So today's guest speaker, guys, we have a good friend of mine who's an attorney dealing in commercial law, correct?
I do, yes, that's what my specialty.
All right. So I'm going to turn it over to her to tell you about what she does, how she got involved with the field of law, and if you guys have any questions, you can send them to me in the chat, and after she gets through talking about what she does, I will relay them to her, and yeah, so it's all yours, Lisa.
Hi, good afternoon. I apologize for being a couple minutes late, a few technical difficulties on my part. So my name is Lisa. I am a commercial litigator. I work for a law firm called Reisman Perez, Reisman and Capobianco. We're located on Long Island. I specialize in something called commercial litigation. I'll talk a little bit about what that is in a moment, but just to give you some background, I went to Hofstra University for undergrad. I majored in history and I minored in political science and American studies. I then went to law school at Columbia University School of Law. From there, I spent a year working for the New York City Law Department, and then I clerked for a federal judge, a federal district court judge sitting in the Eastern District of New York for 2 years before coming to my current firm. So with all that being said, right now I practice something called commercial litigation, and commercial litigation is involves businesses typically. So either there's a contract issue where the parties have entered in an agreement, but they disagree as to maybe how that contract or agreement should be interpreted, or they're saying one party hasn't fulfilled their requirements under the agreement, they haven't done what they've agreed to. Or they might say something what we call a business tort, which could be some sort of wrong in the context of businesses. So maybe it's a kind of like a complicated phrase, but misappropriation of trade secrets. And what that means is, company A maybe has developed and done research on a particular in a particular area, let's say pharmaceuticals, and they have developed a drug to address a certain sickness, but then an employee leaves that company and goes to company B, a competitor, and they decide to take all that information from company A to company B about what they've developed, and that's, you're not allowed to necessarily do under the law. It's a misappropriation of trade secrets, or customer lists, or client contact information. And so what I do is I represent a client, either the plaintiff or the defendant. So plaintiff is the one who brings the lawsuit. The defendant is the one who is being sued. And my firm represents both types of parties. And we engage in what's called litigation, which is what you might see a lot of times on TV is the end of that, which is the trial. But there's a lot that actually happens leading up to a trial. We do something called drafting pleadings, which is the complaint that lays out whatever claims the plaintiff might have against the defendant. The flip side of that is we draft the answer, which is the defendant's response to that complaint about why those allegations might be false or what defenses they might have. Something called motion practice, that is where a party will seek relief from the court, and it involves a lot of research and writing, whether it's a motion to dismiss the complaint because there's some sort of defect in the complaint, or maybe there will be a motion to amend the complaint. There's also different types of motions. We also do something called discovery. So even though it's really exciting on TV or in the movies, when there's some sort of surprise witness or evidence that comes up in a trial. That rarely actually happens. What really happens is there's this something called discovery, where the parties exchange information with respect to who their witnesses are, or what documents they're going to rely on as evidence. And you even have depositions, which is essentially taking testimony before trial of the witnesses. So you have a good sense of what they might say once you get to the trial phase. A lot of cases actually, currently, I find in my practice, don't even make it to trial, because a lot of parties are risk averse. They don't like the risk of what a trial, the unknown that a trial presents, and a lot of cases get settled. The parties come together through their attorneys, and they kind of come up with how they would like to resolve the matter with avoiding a trial. So that's just a little bit of what I do, and that falls within civil litigation. So civil litigation means there's no criminal liability. It's more you know, you might be responsible for monetary damages, or you might be enjoined from taking a certain action, but you're not going to face any criminal repercussions. There is attorneys who practice within the criminal law, and criminal litigation, which is usually called prosecution, is very different than what I do, but it's in the type of area of law. It involves a criminal complaint being brought by the government. Either it's a county DA, or if it's a federal offense, it'll be the United States Attorney's Office for whatever district that offense happened in, and they'll bring a criminal complaint, and they will prosecute that complaint, and a person in that context is entitled to have representation. So if they cannot afford it, you'll have a federal public defender, or a local public defender step in, depending on if it's at the state or the federal level, and they will represent that person. In those cases also involves not settlement, but they have plea deals. So sometimes a criminal defendant will take a plea deal and plead down to something less to avoid being prosecuted to the fullest of whatever the complaint is, and so forth. So that's another type of law. There's also something that doesn't even involve trial work, which is called transactional work. And those are the people, those types of attorneys don't go into a courtroom. They're not, necessarily adverse to anyone. They represent a client in some sort of transaction or agreement that they want to reach with another party. And each party has their own attorney to make sure that their interests are protected, whether it's something really simple, like a simple real estate transaction. I want to buy a house. Dan wants to sell me his house. We each get an attorney. We come together to price and certain other, arrangements. We enter into a contract. That's what one example of what transactional attorneys do. Transactional attorneys also help companies merge together. So if you ever hear on the news about a big merger involving different companies, that usually involves attorneys who are drafting all those agreements to make sure all the parties' interests are protected. So there's a lot of different types of law. Even within litigation, like I explained commercial litigation, but there's also employment litigation, maybe, which involves claims like employment discrimination or unfair wages haven't been paid and things of that nature. And there are attorneys who focus primarily on employment litigation. There is litigation involving other different areas like senior citizens. There's types of attorneys who focus on those issues that involve senior citizens in particular. There's certain issues that often come up, and so they'll resolve that. So there's a lot of different areas. So if you're interested in a law, the way that you, at least in New York, I'll speak specifically about, because that's where I'm admitted to practice. There's a few different things that you need to keep in mind in order to become a lawyer. You need to have a bachelor's degree, bachelor's of art, bachelor's of science, some sort of four-year degree at the undergraduate level. So you'll go to college. You can major. So despite the, you might hear otherwise, you don't need to like major in pre-law. A lot of law students you'll find are history like I did, or English, political science. Those tend to be popular, but you don't need to major in any of those things. There are people who major in something completely different. They might major in drama or some sort of science, and that's totally fine. The biggest thing that law schools look at is like, what was your GPA? How did you do while you were there? So the GPA is an important factor. And occasionally actually having a different major might make you more attractive to some law schools because you sort of stand out. And like a lot of people who are science majors, they particularly become well-versed. A lot of them end up doing like patent law, because patent law, which patents, for those who aren't familiar, is a type of protection you can get for something you invent or design. And it's something that the federal government hands out to protect something called intellectual property. It's just sort of what a person is able to, if they've invented something, or as I said, designed something, it's a protection for that idea. And so people who have a science background can really understand the ins and outs and technicalities involved with that sort of area of law. In any event, after you get your undergrad degree, you'll go and you'll enter a law school program. And typically, there are some exceptions. Typically, it's a 3-year law program if you're attending full time. There are opportunities to do it. I know there are some law schools that do offer like night programs and part-time programs, and then it usually takes longer than 3 years. But if you're doing it, when I say the traditional route, you would go to a 3-year full-time program at a law school. And once you complete that program, you then sit for the bar exam. So let me just backtrack, because I forgot to mention something very important. For law school, besides having an undergrad degree, you need to take something called the LSAT, which is an exam that doesn't test you on the law. It's a standardized test that tests the way you think. It's like a very logic-based test. And it's something that law schools require, although there's been some debate about whether they're going to move away from the LSAT, and there's always kind of disagreements about what should be included and what shouldn't be included on the LSAT. They've revamped it actually quite recently because of some issues that had arisen. But you take the LSAT, and how you score on the LSAT is a very important factor. Probably many people argue the most important factor to determine what law school you'll get into. And so there's a whole ranking system with law schools, and that can be important depending on the types of jobs that you want to pursue. So in any event, so you'll need the LSAT, and then your GPA is probably the second most important thing. And then they look at other things like, what were you involved in? What do you do? What's your writing sample? What sorts of clubs did you do, or other activities, or employment history, etc. So then, as I said, you go to law school. It's a 3-year program. Typically, the first year is the most intense, and it gets a little bit better each year. Your first year summer and your second year summer, you're expected to work within the law field. A lot of times people during their second summer of law school will work at a firm that they're hoping to work with after they graduate. But that's not always the case. That's certainly not the path that I took, but a lot of people take that path. But once you finish law school, you then have to sit for the bar exam. So generally, the bar exam in New York is at the end of July. This year is a little weird because of the coronavirus. They didn't actually hold it in July. I believe they were going to hold it in the fall in September, but that ended up getting canceled. And I think they're doing for the very first time an online bar exam because they don't want to prevent all these new graduates from being able to practice law. But generally, when there's not a pandemic, you would sit for the bar exam in July. It's a 2-day exam. You spend a lot of time preparing for it. Just like the LSAT, there are a lot of test prep companies to help you prepare for it. And funny enough, even though you spend 3 years in law school, you need to take a prep course generally to prepare for the bar exam, because what you learn in law school doesn't necessarily prepare you for the bar exam. It's sort of funny that way, but there's multiple parts to the bar exam. Some of it is multi-state, multiple choice questions. So there are questions that a number of states end up using. And then some of it is New York specific. And it might have changed some since I took it. So I graduated from law school in 2011 and took the bar exam that summer. And so, you know, it's now been quite some time. So some things might have changed. So I apologize if I do not know all of the new updates. But in any event, if you take the bar exam in July, you should get your results by the end of October or the end of November. And you'll learn whether you passed or failed. If you pass, you then go through a process of getting admitted to the bar. You have to include references, and they check your you have to do an interview to make sure that there's no ethical issues, but hopefully everything's okay, and then you get sworn into whatever department you reside. New York has 4 different judicial departments: the first department, the second department, the third department, and the fourth department. I am in the second department, because that covers Long Island, as well as some other counties. But once I'm in the second department, I can practice anywhere in New York. And then if you want to practice in certain federal courts, you need to get admitted into those federal courts. But it's just it's not too, you don't have to sit for another bar exam once you're admitted in New York State. You just have to fill out paperwork to get admitted into those other federal courts. You sometimes need like another attorney sponsor, but if you're working wherever you're working, you should be able to have someone to sponsor you, and so forth. So that's kind of the path to becoming an attorney. And so it's definitely like a lot of work if you want to become an attorney. But it's a path that offers a lot of options, because there are a lot of areas of law in which you can practice. There's a lot of different paths and shapes your career can take. There are attorneys who work in the private sector like I do. There are attorneys who work in the public sector like I used to do. Like I used to work for the New York City Law Department. New York City Law Department represents New York City in all sorts of civil litigation, as well as there were some criminal, but that had to do with, they handled certain juvenile delinquency cases. And so that was the minor criminal law that would come in, but generally it was civil litigation. So slip and falls, like someone got injured on a New York City sidewalk, they might sue the city and that would be litigated. Or someone worked in New York City as a New York City school teacher, and they felt they were being discriminated against based on their gender or their race or their religion. They could bring a lawsuit against the city. There's also something called Section 1983. It's a federal statute, but it has to do essentially with civil rights. So if someone felt like they were some sort of civil rights violation, like maybe they were arrested by the police and they felt they were subject to an unlawful search and seizure under the Fourth Amendment, they might bring a lawsuit against the city saying that the city police violated their constitutional rights under the Fourth Amendment of the Constitution. And so they'll bring something called 1983 action. So there's a lot of different areas of law. So that's just an example of what I did before I eventually became a commercial litigator. And as I said, there's criminal law, there's civil law, there's transactional work, which is within the realm of civil, but it's not being litigating in a courtroom. It's trying to come to some sort of agreement. So with that being said, I don't know if there are any specific questions. I know I threw a lot of information, but please feel free to ask if you have any questions. If nobody has any questions, that's also okay.
We actually do have a few questions in. We had quite a few people
Okay.
commenting that they want to go into the law field.
Okay.
But one question I have here is, why did you decide to go into law?
Gee, that's an interesting question. I kind of knew from early on I wanted to be an attorney since I was in middle school, to be quite honest. I just knew it was something that like I was interested in. And then when I got to college, I still had an interest in law school, but I had also thought about academia. And I ultimately decided law school. I like And so one thing that's really involved with being a litigator, more so than actually arguing in the courtroom, is research and writing. So much of what you do as a litigator is get a problem and need to do the research to kind of try to see if you can find a solution to that problem. One big thing that in the common law, in New York, the U.S., generally the United States legal system, most of the United States is a common law system, each of the states, but except Louisiana is civil law, which is very, very different. Not very different, but it's different. But generally, we're a common law system, and so a lot of the way our law is developed is through case law. And case law is just the decisions of the judges who come and the courts that come before. And so you try to, when you're researching, you try to see if you can find cases that are similar to the facts and issues you have in your case. And it's usually not going to find an exact match, because then you wouldn't necessarily have litigation on it, because it would then be like, well, why are we litigating this? It's pretty obvious what the solution is. But you'll try to find ones that are similar to what you're going on, so then you can argue your point of why the case should be resolved in a certain way. So once you find what you need, and you can also look at, although it's not as persuasive, and there's some cases are holdings, and so they're not necessarily persuasive. There's something called stare decisis, which is like a fancy term, but basically the courts are supposed to follow what came before, and not necessarily, because if every court kind of went in its own direction whenever a similar issue came up and didn't sort of respect the rulings of previous courts, then we'd have like no predictability and everything would be all over the place. But you can also look at treatises. Obviously, if there's a statute, you're going to look at the language of the statute, but a lot of times the statute has been interpreted by the courts, and so you look at previous decisions interpreting that statute. But in any event, I like the research, so I research and try to find what's the answer, how can I find cases that apply to what I have, and then sort of bring it all together in a written argument and a written presentation. So I really like that aspect of the law, and particularly that's what you find in litigation. You wouldn't find that necessarily in trial practice. I'm sorry, transactional work. You also don't find that, as I should say, in trial practice. So criminal work, you don't really have the same type of motion practice, and so you probably will find, if you do criminal work, you find yourself in the courtroom a lot more. Not to say that in civil work you don't find yourself in the courtroom, it just doesn't happen as often because a lot of cases get resolved on motions or they get settled.
Okay, I have another question here.
Mm-hmm.
How long have you been working in the law field?
So it's a little like you have this period of time when you graduate and you're waiting for your bar results, typically, that you're working as sort of like a law graduate pending bar results. So I started working in September of 2011. So I graduated in May of 2011. I took the bar at the end of July. I gave myself a month breather, and I started in September of 2011. So I've been working since then. So it's almost been 9 years. But that period of time between starting work, finding my bar results out and then getting admitted, there was a few month period. And so I became an admitted attorney in January of 2012. Because even though I got my bar results, positive bar results, I think it was the end of October. It's a period of time and you have to get on the schedule. They only admit a certain number of people each day. And so you have to wait for that to, for you to get on the schedule. I actually got on the schedule rather early because I worked for the New York City Law Department, and they try to get their attorneys approved quicker just because their attorneys, they have practicing, like they need them to get into court right away and submitting papers. So actually the day after I got admitted, I was presenting an oral argument in the second department the very next day. Because you just can't do certain things until you're officially admitted. Which is like you can't sign any paper that gets submitted to the court. You can't appear and present argument before the court until you're an admitted attorney.
Okay, I have a question here from Cameron. What's the largest settlement you've ever seen?
Gosh, well, I don't know. That's a good question. I mean, one of the problems is, and why I might not be able to answer that question, is a lot of cases, settlements are usually kept confidential. So you don't always get to know, like obviously if I worked on the settlement and you've had some significant settlements in my office, I would know it. But generally you have to keep it confidential. A lot of times the parties don't want to reveal what the number is or how much they settled for. I mean, some cases will settle for millions of dollars, but that's because if they go to trial, they could risk maybe billions of dollars. So it really depends on the case, but usually you want to include in whatever settlement agreement you draft, like a non-disclosed provision where the parties don't share. So certain other things you include in a settlement agreement, like you'll include a release and waiver of liability so that the parties say, once we enter this agreement, all issues that were raised or could have even been raised, even if they weren't raised, are finished. Nobody can bring them up, no more lawsuits or anything of that nature.
Okay. I have another question here from Tristan.
Mm-hmm.
How busy of a job is it?
That's a really interesting question. It can get very busy. It really depends on where you work, what if you work at a private practice, your firm might have different expectations. There's something called billable hours, which a lot of attorneys don't like, but basically it's how you generate revenue as a private firm, where you essentially have to log. We do it by 6 minutes. So every 6 minutes of time, you have to account for what you're doing. So if I work on a motion, it takes me 2 hours and 18 minutes, it would be 2.3. That's how much time I bill. And so each firm has a different requirement for their associates about how many hours they hope that their attorneys bill. There are attorneys who work in big city law firms in Manhattan, for instance, they work an insane amount of hours, which is, wonderful if that's what they want to do. That was not necessarily something I wanted to do. I have a very nice and busy practice, but I have a nice also work-life balance. Attorneys in the public sector, while there might be the assumption that, they don't work as hard as a private sector attorney, that is also not true. They can have very demanding hours as well. It really depends on what's going on. I can speak from the litigation perspective. If you have certain court deadlines coming up, and you have to get a motion for summary judgment out the door, that's gonna take up some time. But sometimes it's a little quieter. Summer tends to be quieter. Right now, because we had this, break in work because of the pandemic, things are actually a little bit busier this summer because things are slowly starting to go back to normal. If you're on trial, you're going to be very, very busy for that period of time, whether it's a week trial or a little bit longer, a little bit shorter. Some trials can go a lot longer, but you'll be very busy during that. Transactional attorneys, I'm not a transactional attorney, but my impression is that their hours can also ebb and flow depending on what's happening. A lot of times towards the end of the year, it can get very busy because a lot of people want to close deals before the new year. It depends if there's like certain deadlines. There's a little bit more predictability, I think, with litigation because you kind of get your court deadlines, when things are. There'll occasionally be an emergency that comes up, there's something called a TRO, a temporary restraining order. Maybe if a party runs to court and they need emergency relief and they want a temporary restraining order to prevent the other party from doing something, then all of a sudden you have to stop what you're doing and address that. And clients always have needs, and sometimes you have to manage and balance that, or deadlines end up kind of all falling into place like around the same time. But it's a little bit easier, I think, to manage your calendar as a litigator than as a transactional attorney. With all that being said, it really depends where you work, and that's something to always look into and inquire about as you're applying for different firms or even different public sector jobs, wherever you're looking to see where you want to go as an attorney. You can think about, well, what is my work-life balance going to be here? And some places are better than others. And there's always a trade-off, because at the same time, those big city law firms, they make a lot of money. So it's the trade-off. And some people it's worth doing for a few years, or, they just really love working anyway, so they want to work that much. Other people enjoy their work, but they also enjoy their family time, so they want to be maybe at a firm that has a little bit of a better work-life balance.
Okay, I've got another question here from Andrew. How has your
Okay.
job changed due to COVID-19?
Oh, that is such an interesting question. So it has definitely been interesting. For instance, I have a court conference tomorrow in Nassau Supreme Court. And funny trivia, in New York, our trial courts are called Supreme Courts. So while obviously the federal United States Supreme Court is the highest court in the land, in New York, the Supreme Court is the lower court. It's the lower trial court. And then we have something called the appellate division. That's where you appeal to. And then the highest court in New York is the New York Court of Appeals. So fun fact. But in any event, typically I would go to that status conference in person. We've been doing a lot of things via Zoom or other types like Skype. There's a Skype meeting way to do the video conferences or even telephone conferences. Depositions is another thing. So typically depositions are done in person, although there have been in the past times depositions are not done in person when the person lives very far away. For instance, if we wanted to depose someone in Florida, they might not necessarily travel to New York for the deposition if they have a health issue or whatever. But generally they're done in person. Now we're sort of navigating, do we do depositions in person or do we do them via video conference? But it's a very different dynamic doing it that way. And there's also court reporting companies that are offering facilities that are sort of implementing social distance measures to make it so you're doing a deposition in person, but there's sort of a divide or a plexiglass or something like that, and the distance that's needed. The thing, a lot of so we weren't allowed back in the office until phase 2, which started in mid-June. So from mid-March to mid-June, we were working from home. And it's interesting because a lot of what I do, I could do remotely. I could do the research and writing. The courts moved away from, a lot of times the courts, even if you did an electronic filing, they would want a paper courtesy copy, but they did away with that requirement in light of coronavirus. But there were certain things that were really big obstacles to do not in the office. One of them, for example, was when I mentioned discovery, that's where you share you know, the parties make requests of one another for what documents and evidence you have that are relevant to this case. And I had hundreds of pages that I needed to go through. I need to redact certain information that was private that shouldn't be turned over to the other side. And so I had the originals. I would need to make copies of hundreds of pages and do these redactions without the, you know, my support staff here, which is very important at any firm. Although, you know, you think about the lawyers, the support staff is extremely important to get anything done, like the paralegals and the legal secretaries and things like that, or people like that, I should say. They are super, super important, and they do so much incredible work. But without them, you know, without being able to be in the office with them to have them help me, it was really impossible. And I have a home office copy printer scanner, but it does not replace, you know, a big commercial office printer scanner. So, you know, we had to get certain adjournments or extensions of time in order to comply with discovery. It's just a lot of things being pushed over just because people needed more time in order to, you know, do a lot of the work that we do. So, I mean, we certainly adapted and were able to do things what we could remotely, but being back in the office does have a lot of advantages. I just don't know when we're going to be going back to courts. Courts are on Long Island. Some of them, they are open, but very limited appearances. In New York City, like I have a case in Brooklyn, for instance, and like nobody's going in. I mean, they have some exceptions for emergencies, like if there's an emergency application that needs to be considered. My understanding is for like criminal prosecutions and indictments and arraignments, they have to have some sort of, they've been doing some things by video, because those things you can't really necessarily hold off on. Like if you arrest someone, you need to arraign them, and you know, you need the courts to be able to do that. So they've been I know they've been implementing certain things to sort of address that as well. So it has been interesting. It's getting a little bit more normal now, but we're still doing a lot of things virtually, especially with the court. You know, that nobody's really appearing in a court right now.
Okay, I think we got 2 more questions here in the chat. And
Okay.
we'll wrap it up. But so this one's another one. Actually, let's do this one first. So this scout, you sent it over in all caps, exclamation points. He really wants to know the answer to this one.
Okay.
How has your job changed you?
How's my job changed me? Huh. That's a really good question. I think that in terms of my growth as an attorney, I think that I have really, like my firm has been really invaluable in terms of letting me have ownership of my cases. So I handle my cases from the pleading stage, which is either the complaint or answer I spoke about before, all the way through either trial, or if we go on appeal, I handle all those and everything in between. And I have become a really strong research and writer, particularly because of that, because there's a lot of motion practice involved. I think that I think I've developed a certain savviness that I didn't necessarily have previous. Maybe a certain degree of cynicism. I think all attorneys are a little cynical. But I like to think of it more as street smarts and being, you know, critically thinking about problems, having, I think, you know, understanding a little bit like what my rights are as a person, what my friends and family rights are, you know, so you're more likely to, at least I find I question things more, which I think is good. You don't take things as face value necessarily. You look at everything with a critical eye. And obviously that could always go to the extreme, but I think because as an attorney, I sort of now have a sense of like where that line should be as well, because I'm experienced enough to have seen all sorts of different types of disputes and issues. One thing I mentioned briefly was I clerked for a federal judge, and that is like the best job in the world. If you go to law school and you have the opportunity to clerk for a judge after law school, I highly recommend it. It is not always easy to get those positions, but it's wonderful. And the federal judge I clerked for, he actually unfortunately just passed away. Wonderful, wonderful person. But you get exposure to so many different types of cases and areas of law. And so I think then you become aware of what your rights are and also what your rights aren't, in terms of, it's funny because sometimes you get clients and they'll say, well, X person, lied to me about Y, and that's, so they committed fraud on me. But you learn, well, that's one element of a fraud, but there are a lot of other elements that go into making a claim for fraud. And just because someone lied to you about something doesn't necessarily mean you have a claim for fraud. There needs to be, a causal link between the misstatement that they made to you and maybe some action that you took, and that has to lead to some sort of damages that you faced. So I think you just get like a better sense of what the law is, what your rights are, what other people's rights are, so I appreciate, having that knowledge.
Okay, I think our last question here is, what has been your favorite part of the law field?
Well, I guess I touched on it. I guess having worked for the federal judge was such an honor. His name was Judge Arthur D. Spat. He was, and I'm very sentimental about my time there, and even probably more sentimental because he just passed away in June. So I've been really reflecting on him. So if you have the opportunity to look him up, he was a World War II veteran, and he served on the bench for 25 plus years on the federal bench. And before that, he was a state court judge. He lived to 94 and a half years old and was working full time. Like, he worked 6 days a week. He was a very, very hard worker. And in any event, it was an honor to work not just for him because he was such a wonderful mentor and person, but to just work in the federal judiciary. And as I said, you get exposed to a lot of different cases. You have this privilege of also being able to help the judge look at and consider the motions before him and draft decisions. So then you're contributing, because as I mentioned, in our legal system, the law is developed through the decisions of judges. So you're shaping the law when you're helping the judge issue his decisions on whatever problems are before him or whatever cases. So it's a really special and unusual and unique opportunity that I had. And so that was probably will always be one of my favorite experiences. The other thing that, even though trial work, so I have had I did a couple of bench trials, and this last one, even though doing a trial, whether it's a bench trial or jury trial, and just to give you a distinction, a jury trial is usually what you see on TV or in the movies. You have the jury box. It's typically for criminal, it's 12. Civil, it doesn't always have to be 12 jurors, but in any event, a bench trial is where the trial is conducted just before the judge, and so the judge is both the arbitrator of the law and also of the facts. And when you have a jury trial, the jury determines the facts, and the judge is the one who announces what the law is. And so he presents what the law is, and then the jurors, figure out the facts, like or certain elements reached. But in any event, it's a lot of work. But when you win, it feels really good, especially when you feel strongly about your position. And so we just had a bench trial, and we spent a lot of time on it, and we spent a lot of time doing research. When I say just, we had it in the fall, and then it took the judge until the spring to get a decision. Which is not unusual. It can take a while to get decisions. And so that felt really good, especially when you felt like you had a strong position. With that being said, one thing you get used to very quickly, which is maybe another good thing that you learn as an attorney, and what I've in my own personal growth, you're not always going to win. Litigation, even, sometimes you just have a loser, like a case, the facts aren't in your favor, the law is in your favor. Sometimes you feel like those things are in your favor, but the judge just sees the whole case differently. And so you sort of like get thick skin in that way. You always do your very best. You argue and you get the facts. You approach the facts and the law to the very best of your ability in favor of your client. You present the very best arguments you can, but you learn to accept that you can do your best and you still might lose. And that's just the nature of litigation.
Okay, thank you. One last thing I have, if you could give advice to any of our scouts who might be considering a career in law, what would it be?
Sure, I guess a couple of things. Think about, as I mentioned, those requirements, if you will, to get to law school, so that you can put yourself in the best position to go to the best possible law school, because that can affect the different job opportunities you might have, and also scholarship money, because law school is very expensive. So always think about, I know people don't always talk about this, but you want to think about how much money you're taking out in terms of student loans versus what's the possibility of how much money you're going to make in paying back those student loans, because it can be a lot of money. Like I always joke, I could have bought a house with what I paid to go to law school. So you always want to think about that. And I know it's like not always thought about. It's like so easy because you don't always conceptualize like, oh, I'm just going to take out this student loan and I'll pay for it later. But it does have an impact on you later. So you just want to think about that and like what scholarships are available and things like that, I think, to lessen how much student loans you take out. But think about your, whatever you major in. So major in whatever you want and whatever you enjoy. It doesn't have to, as I said, be pre-law or not all schools even offer pre-law, but it doesn't have to be like the traditional like history, English, political science. Major whatever you like. Just think about making sure you do well in your classes, you have a strong GPA. And the other thing is definitely LSAT is an important test. So take the time to prepare for it. It is a test you can prepare for. The LSAT company, the administrators of the LSAT, they offer, you can buy the practice test. And this is not something you would do until you're actually in college. You'd start preparing for the LSAT. So those are things that I would recommend that you do in terms of positioning yourself to get to the most ideal law school, and give yourself opportunities for scholarships and things like that. The second thing I would suggest, if you can, while you're in college, get the opportunity to intern in some sort of legal way. It might be harder to be an intern at a private firm. I don't think they have that many opportunities for college students in the private firm, but you might find opportunities maybe like more in the public sector. Just sort of, you can even ask your career, counselors in your college, even in high school, if you can find the opportunity to do a legal internship. It wouldn't be a legal internship like a law student would do, but it would still, if you can even like do a shadow program or something of that nature to kind of get a sense of what the law, what it's really like, because it's not necessarily like television or the movies, it's different. And there are lots of different areas. So take the time to start reading and thinking about the different areas of law and what area you might want to go in. And also think about too, like you might be interested in human rights law, for instance, which is a very interesting and commendable area of law, but the job opportunities might not be the same, and the salaries might be different than maybe a big private sector law firm. And so those are all things to think about too. So, but definitely if you can get yourself, when I was a law clerk for Judge Spat, he had both legal interns, so those are law student interns, but he also had like undergraduate interns. He had a few of those. So some of the federal judges might have those opportunities. And some of like the district attorney's offices might have those opportunities, and you kind of just can get like a bird's eye view of what certain areas of law might be like.
All right. Thank you so much for joining us and providing
You're
all this
welcome.
information. It's been fantastic having you with us. So guys, let's get a round of applause for our guest speaker today.
Thank you. Thank you. It was very nice to be with everyone. I wish everyone well during this insane time, and I appreciate you having me.
Thank you again. All right, Scouts. So just a reminder, if you're having trouble getting into your merit badge classes, make sure you email Mr. Zayas. You're down day one already. Great job with all those badges. Cub Scouts, if you're having any problems with your crafts that we send you at home, make sure you email Mrs. Gifford and she'll help you with those. And we will see you for our opening at 8:45 in the morning. All right, thank you for joining. Bye.
Bye.